Assalamualaikum warahmatullahi wabarakatuh. Today we are from Group 5. We present about law of partnership, relation between partner to one another, and the solution of partnership. First, overview of the slide consists of 6 parts. First, introduction. Second, what is partner? Third, relation of partners to one another. The solution of partnership, case example, and the last one is conclusion. Next, we move to introduction. First definition, partnership is the relation which subsists between persons carrying on business in common with a view of profit. The importance and its purpose. A partnership agreement outlines the rights, responsibilities, and obligation of each partner as well as the overall goals of the partnership. It also provides a framework for resolving disputes and can help to avoid misunderstanding and the dissolution of the business.
For now, what is partner? According to Section 7, every partner in a business partnership acts as a representative of the partnership and the other partners when conducting the partnership business, unless if the partner didn't actually have the authority to take the specific action, or if the person they are dealing with either knew the partner don't have the authority or they believe is not a partner. According to Section 8, if someone, partner or non-partner, acts on behalf of the partnership in its name or in a way showing intention to bind the firm, and they have the authority, the action is binding on the partnership. According to Section 11, all partners are jointly responsible for the firm's debt. After a partner's death, their estate is liable for unpaid debts while they were a partner. Liability of incoming and outgoing partners. Section 19(1) states that if someone joins an already existing partnership, they are not responsible for any debts or liabilities the firms had before they joined. And for Section 19(2), if someone leaves a partnership, they are still responsible for any debts or obligations the firm had when they were a partner, even if they retire. Now let's look at relations of partner to one another. Section 21 states that partners in a business can change their rights and responsibility to each other by agreement or by action. Section 22(1) states that any property or rights like land, buildings, or equipments that were originally brought into the partnership by any partner, later bought or acquired for the firm's business, are considered partnership property. When co-owners of land, which is not considered partnership property, collaborate to make profits from its use and then use those profits to purchase additional land for similar purposes, the newly acquired land will belong to them individually as co-owners, not as partners. Section 23 states that unless stated otherwise, any property purchased with the firm's money is considered to be bought for the firm. For procedures against partnership property for partners separate judgment debt. According to Section 25(1), if someone wants to collect a debt from a partnership, they cannot directly seize the partnership property unless there's already a judgment against the entire firm, which is the business. For Section 25(2), if a creditor has a judgment against one partner individually, they can apply to the court to charge the partner share of the partnership property and profits to pay off the debt. For Section 25(3), the other partners in the business can take action to stop the creditor from taking the partner's share. Section 26(a) states that equal sharing of profits, capital, and loss, which means all partners are entitled to share the profits of the business equally, regardless of how much capital or of effort each partner put in. If a partner ends up paying money or facing personal legal responsibilities like debts or damage while running the business, the firm must cover those costs in the following situation. A. If the partner was acting within the normal business activities of the firm, or if the partner did something necessary to protect the business or its property. Section 26(d), a partner cannot earn interest on the money they invested in the business until the partnership has determined its property. And lastly, if every partner has the right to be involved in managing the business. And moving on, expulsion of partner. Section 27 states that no group of partners in a business, even if they are the majority, can remove or kick out a partner unless the partnership agreement clearly says they have the right to do so. Section 28(1), if there is no agreed upon time for the partnership to end, any partner can decide to end the partnership at any time. To do this, they just need to let the other partners know about their decision. And Section 28(2), if the partnership was originally set up in writing, like in a formal agreement, such as contract, the partner who wants to end the partnership can simply write a notice, sign it, and send it to the other partners. Section 29(1), if a partnership was originally set up for a fixed period and the partners keep running the business after that period ends without making a new formal agreement, their rights and responsibilities stay the same as they were before the fixed term ended. And Section 29(2), if the partners continue the business after the fixed term has ended, and if the partners who were regularly involved in the business continue working, it is assumed that the partnership is still ongoing. There's also duty of partners to render accounts. For example, according to Section 30, all partners in a business are required to be honest and open about the business financial matters. For Section 31(1), if one partner makes money or benefits from something related to the business, like using the business property, name, or connections without getting approval from the other partners, they must give that benefit to the partnership. And lastly, for Section 32, it states that if one partner starts a business that competes with the partnership's business without getting permission from the other partners, that partner must give all the profits from the competing business to the partnership.
Dissolution of partnership in Malaysia. We'll be discussing the dissolution of partnership in Malaysia governed by the Partnership Act 1961. We explore the key sections and types of dissolution along with important considerations. The dissolution of partnership is primarily regulated under the Partnership Act 1961, focusing on Section 35, compulsory dissolution, and Section 37, court order dissolution. Types of dissolution. There are three main types of partnership dissolution. Voluntary dissolution. This occurs by mutual agreement among the partners or as outlined in the partnership agreement. Steps include reviewing termination clause, obtaining mutual consent, unless unilateral action is permitted, and notifying relevant authorities, creditors, and stakeholders. Second, compulsory dissolution, Section 35. This happens when business operation become unlawful due to legal or regulatory changes. Examples include unlawful business, if legal or regulatory changes make the business illegal, such as using restricted chemicals. Project completion, the partnership dissolves upon completing the project, such as building construction. Death or bankruptcy of a partner. Dissolution occurs automatically unless the agreement states otherwise. Third, court order dissolution, Section 37. The court may order dissolution on grounds such as breach of the partnership agreement, partner misconduct that harms the business, situation where it is just and equitable to dissolve the partnership. The court will review financial records and other relevant evidence to decide. Key considerations. Compliance with the partnership agreement is crucial to foot the dissolution process. It's important to explore alternatives like mediation or arbitration to avoid court proceedings when possible. Even after dissolution, partners remain jointly and severally liable for any debts unless creditors explicitly release them. In summary, understanding the legal framework and proper procedures for partnership dissolution is essential to protect the interests of all parties involved.
So moving on to the next part, which is the case example. In the case summary between Ten Hog Tech and OS, we Muhammad Afrizan bin Hussein and another appeal. So as in the price, a partnership formed on October 8, 1992 faced significant legal dispute involving its partner and external parties. So it includes 4 partners and the administrator of a deceased partner estate. The first defendant claimed a 5% share in the partnership and appoint the third defendant as their representative. So multiple civil suits were filed, and including a lawsuit demanding about RM 6 million. So the legal proceeding that happened here is the first defendant filed a creditor petition to wind out the partnership for the same amount while the lawsuit was pending. So the court granted the petition and appoint the second defendant as a liquidator. So the plaintiff contest the winding up order, arguing that there was a dispute fact need resolution in a full trial. So they question whether the partnership could be considered unregistered under Section 314 of the Company Act 1965. So after trial, court find that significant dispute facts requiring a full trial, leading to the summary judgment being set aside. So the court agreed with the Court of Appeal interpretation of Section 314, determining that the words were clear and unambiguous. So the term foreign company and any partnership was to be read distinctively, meaning foreign only apply to company and not the partnership. So in conclusion, to the case summary between Ten Hog Tech and OS, we Muhammad Afrizan bin Hussein and another appeal. The court examined whether action could be taken against the receiver without the leave of the original court that appoint the receiver, concluding that whether leave was required depending on the merits of the case. So the court also considered whether leave was necessary before commencing garnishee proceeding against the receiver under rule of High Court. So this case highlight the complexity involved in distribution of asset and the protection of creditor rights in a partnership under receivership. So moving on to another case with Lee Shoyam Holdings and OS with Hu Yok Hua and OS. So case background, Tai Kwong Goldsmith and Jewelers, a partnership, went into receivership, leading to a complex legal situation involving multiple parties. So the first intervener, Ms. Sahira and Woon, had RM 1 million as a stakeholder for the receiver in 3 lower court garnishee proceeding initiated by the second intervener and 2 others. So the second intervener along with 16 others were deposited with the partnership. So on September 13, 1992, the first intervener obtained an ex parte order from intervene, an injunction to prevent the second intervener and another party from enforcing the garnishee order absolutely against them. So further injunction were also obtained against other intervener who had not yet obtained judgment. So court finding, the receiver then filed an application for direction regarding the priority of payment between the second intervener and 60 others as depositor and the former employees of the dissolved partnership. The court had to determine whether the distribution of the partnership assets should be on a pari passu, actually equal, as there was no provision for ratable or pari passu distribution. The court emphasized the application of equity to protect the partners, ensuring that debts were paid despite the appointment of a receiver. So in conclusion, for this case, the appeal were dismissed with cause and the court upheld the decision to wind up the partnership and appoint a liquidator. The court emphasized the need to determine the number of members in the partnership at the time of the winding up petition in a full trial. So this case highlight the importance of resolving disputed facts through a full trial and specific legal interpretation of statutory provision.
Lastly, conclusion, the Partnership Act 1961 provides a robust legal framework for partnerships in Malaysia. It outlines the rights, duties and responsibilities of partners, including their relationship with one another and with the partnership itself. By understanding the provision of this Partnership Act and entering into a comprehensive agreement, businesses can leverage the benefit of partnership while mitigating risk.